Welcome to today's program titled Half an Hour for Healthcare, Part 4 Best Practices and Arbitration Agreements for Healthcare Employers. At this time, all participants are in a listen-only mode. For those of you who are logged in to the live web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down as it will not be reread and is required on the CLE credit request form. During this program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received yesterday afternoon. Copies of the webinar recording and materials will be distributed to all attendees within a day or two following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Daniel Wong. Daniel, please go ahead.
Thank you so much. Welcome, everyone. It is my pleasure, along with my colleague Galen, to present a topic that is increasingly important, especially to those in the healthcare industry, and that is arbitration agreements. Next slide, please. This is a topic that we can easily go and talk about for many, many hours. We certainly won't subject you to that today. Here is an agenda of 3 very quick topics that we want to address. And it is just a high-level summary of some key factors to consider when deciding whether to roll out an arbitration agreement and how to roll out an arbitration agreement, including both the implementation and some key provisions that need to be included in an arbitration agreement. Again, there are many, many topics and subtopics within these that we can discuss at length, but the point of and purpose of today's presentation is to provide a very high-level overview of some key considerations. Next slide, please. So what I will discuss first is the pros and cons of arbitration agreements, and there are several that are very important to consider. And it is not necessarily a foregone conclusion that every employer will roll out arbitration agreements. And so the first question to really grapple with is, are arbitration agreements something that a company should implement? And so to help go through that evaluation, we wanted to highlight some of the key pros and cons of arbitration agreements. So we will first start with advantages of arbitration agreements. And right off the bat, the bottom line is that the key benefit of arbitration agreements are the ability to waive class and collective actions. And so that's the first topic here, is reduce exposure to multi-plaintiff wage and hour suits. And so what we mean by that is, and hospitals especially are being attacked very, very frequently with class actions and PAGA actions. And these cases are usually brought based on wage and hour violations that are alleged in the complaint, seeking to represent all non-exempt employees, typically over a 4-year period in class actions and a 1-year statute of limitations for PAGA actions. And these cases have incredibly high potential exposure, and there is significant downside to employers with very little upside in these cases. And what an arbitration agreement permits is the ability to knock out the class action and make a class action a single plaintiff wage hour case, with the exception of PAGA, which we will get into in a little bit. And that dramatically reduces the potential exposure of any of these cases. And as long as the employee is covered by the Federal Arbitration Act, which is, and for hospitals, they will be, for healthcare, any employee in the healthcare industry generally will be, as long as, for instance, the hospital participates in Medicare or receives drugs or equipment from out of state. Those are going to be generally sufficient to have the employee fall under the Federal Arbitration Act. The exception is generally limited to those companies that don't engage in any interstate commerce and the employees who may be within a class of workers called a transportation worker, which generally doesn't apply to the healthcare industry. So that is first and foremost the biggest advantage of arbitration agreements and the reason why any hospitals or healthcare institutions that want to roll out an arbitration agreement usually do because of that very first advantage. Another advantage is theoretically faster and more efficient decisions. And the reason I want to qualify that is it's not always the case that arbitration is faster. Some courts will make sure that cases are tried within 12 months, for instance, and arbitrators, depending on who the arbitrator is that's selected, it can be well more than a year before the evidentiary hearing. But typically it is supposed to be faster. It certainly can be more efficient as well. There aren't the typical repeated case management conferences, the requirement to have formal motions for discovery disputes. Things can be resolved just by a simple call with the arbitrator with all parties. So there certainly is the potential for it to be quicker, and it certainly is generally more efficient in terms of less formalities. Also, depending on what the arbitration agreement says, but as a whole, there is going to be less discovery permitted in arbitration. And arbitrators are very, very keenly aware that arbitration is supposed to be quicker, and therefore they will take seriously, at least in my experience, they'll take very seriously the idea that discovery shouldn't be as broad as it normally would be in state or federal court, for instance. And there also is generally going to be less motion practice. One, for instance, most arbitrators will require that a party can't even file a motion for summary judgment or a dispositive motion without getting approval from the arbitrator. Also, discovery motions generally are non-existent in arbitration. It's going to be based on an informal submission. So that's the second advantage of arbitration agreements. Related to that, and we were talking about, it depends on the arbitrator, and certain arbitrators may have certain preferences. Another advantage is there's the ability to exert more control over who the arbitrator is. Whereas in state court in California, for instance, you could get one peremptory challenge, and in federal court, there really wouldn't really be any grounds for a peremptory challenge. But in arbitration, the parties are able to either mutually agree on an arbitrator, or if they're not able to, there is usually a strike and rank process. So there is more ability to exert control over who the arbitrator ultimately will be. Arbitrations also are generally more confidential. They're not a matter of public record. No one can easily go onto a website and retrieve pleadings as they could in federal or state court. And also, there's more predictable outcomes in the sense that the decision is not going to be made by the black box known as a jury. Now, one potential downside, which we'll get into, is that sometimes arbitrators will take a split the baby type of approach, middle of the road, and give both sides a little bit of something, rather than giving an award that's entirely favorable to one party or the other. But we typically do not see these runaway awards like we would see in a jury trial. And this actually sometimes disincentivizes plaintiffs' lawyers, who some of whom make it their entire living to dupe juries with their trial tactics. And once those particular attorneys learn of the existence of an arbitration agreement, they may be much more willing to resolve the case, whereas in the absence of one, they might continue to be very unreasonable in their demands because they believe they can fool juries into awarding very large awards. Next slide, please. Now I want to briefly go over some of the disadvantages of arbitration agreements. And a key one is that the law in this space is constantly changing, and it poses a challenge for enforcing arbitration agreements and also drafting arbitration agreements. We are seeing an uptick in very, very creative arguments by the plaintiff's bar. One thing I had mentioned is that PAGA claims are not subject generally to a a waiver, a class action waiver, or even an arbitration agreement. The one exception is that, again, a topic we could go at length over, but the U.S. Supreme Court in Viking River Cruises versus Mariana decided that the individual portion of any PAGA claim can be arbitrated, but the non-individual portion involving other employees must remain in court. After the legislative changes to the PAGA statute, the ability to arbitrate the individual portion of a PAGA claim has become more important. But this is one example of a potential creative argument that the other side has been raising, is that they are pursuing what's called headless PAGA cases, where they're saying that we're not even pursuing the individual portion of a PAGA case, we are only pursuing the non-individual portion. And courts have generally said, and this is subject to review right now by the California Supreme Court, but they have generally said that in that situation, the case cannot be arbitrated because there is no individual portion to be arbitrated. We are seeing many arguments about unconscionability and whether an agreement was even executed in the first place. And given that numerous courts in California and certainly the legislature are hostile to arbitration agreements, we see many unfavorable decisions coming up pretty regularly. And so it does subject the risk of legislative or legal change. There's also an exception under the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. That was an amendment to the Federal Arbitration Act that carves out or gives the ability for employees to revoke an arbitration agreement for any claims for sexual assault or sexual harassment. So that is something that cannot be arbitrated. And there's continued efforts by the legislature to try to invalidate arbitration agreements. There was an effort by the legislature in a statute we refer to as AB 51, trying to outlaw mandatory arbitration agreements. But as long as the employee is covered by the Federal Arbitration Act, the Ninth Circuit has held that AB 51 is preempted. Now, another disadvantage is, in light of the class action waiver, a tactic that many plaintiffs' lawyers are beginning to follow is what we refer to as either mass arbitration or numerous individual arbitrations. And they'll say, okay, well, employer, you need to pay for all of the fees associated with arbitration. So we are going to file 10, 20, or even 100 individual cases, and you get what you're asking for. You don't want a class action, but now you need to bear the burden of a mass arbitration. So we are seeing an increase in that tactic. And arbitration is not cheap. The employer is going to have to pay for the fees associated with an arbitrator, which can be anywhere between $50,000 to $100,000 on average. And there's also, absent specific drafting or language in an arbitration agreement, there's also going to be limited appellate review. So that's something to keep in mind. And also that there can be an impact on employee relations. So employees might view the implementation of an arbitration agreement as being unfair or having a negative connotation. So that is something that an employer has to be aware of. And finally, as alluded to briefly, the non-individual portion of a PAGA case can't be subject to arbitration or waived. So an arbitration agreement won't eliminate the ability for a plaintiff to pursue a PAGA claim, but it certainly can provide some leverage to the employer. So with that, I am going to hand this off to Galen.
Hello, good morning or afternoon, everyone. I'm going to briefly talk about some essential terms that must be included in all arbitration agreements in California. If we could go to the next slide. Now, at a high level, I mean, obviously, an arbitration agreement can dramatically reduce your litigation costs and your exposure to general categories of litigation. But that's only if the agreement is enforceable. So what I'm going to cover briefly is what can you do and what do you need to do in order to make an agreement enforceable. So the California Supreme Court has held that arbitration agreements are substantively unconscionable if they do not provide for certain protections for employees. So practically what this means is there's a somewhat lengthy checklist of specific terms which must be included in any arbitration agreement in order to be enforceable in court. Now, this list is almost constantly being litigated, so there are a lot of updates, but generally what this requires is what the courts would call, fairness. Your arbitration agreement can your arbitration is governed by the agreement and it is streamlined, right? But it must mirror kind of the key aspects of litigation. So it needs to provide for a neutral arbitrator, adequate discovery, a right to counsel, a written decision. In general, we counsel our clients to avoid shortcuts that would substantively limit employee rights in order to avoid having the arbitration agreement declared unenforceable. Once this happens, typically it's blood in the water for plaintiffs' counsel. They see, oh, this company has an arbitration agreement, it's unenforceable, and then you get a lot of tag-on litigation. So it's very important to make sure you get the arbitration agreement right and that all of these terms are included. Now, one other thing that's not on the slides that I would like to specifically mention, a recent development, a lot of there's different types of arbitration acts. There's one in California and there's the Federal Arbitration Act. In general, we recommend that the Federal Arbitration Act be the governing law, as there are certain, it's slightly better for employers in a variety of ways. But you know, that's kind of getting pretty far into the weeds. Can we go to the next slide to talk about the most important benefit of the arbitration agreement is to include the class and collective action waiver. Now, for quite a while, there were open questions about whether collective action waivers were or were not enforceable. The most recent decisions have held that these are enforceable, and specifically under the FAA. And as Daniel mentioned, there's a lot of constant ongoing litigation about whether these do or do not apply with regard to the PAGA, or the Private Attorney General Action claims in California. Blanket waivers generally may not hold, especially when it comes to waiving representative claims in California. Those are enforceable, or those plaintiffs can bring representative claims in California. This issue is currently on appeal to the Supreme Court. It has not yet issued a decision, so there will be an update on this shortly. Strongly recommend that you keep an eye out for that, because that will substantively affect a lot of ongoing litigation as well as potential future litigation. Can we go to the next slide as well? All right. Now, whether you have an arbitration agreement currently or you're planning on rolling out a brand new arbitration agreement, there are numerous things that you should keep in mind when you're considering how to roll out your arbitration agreement. Thank you. So even if you have a current arbitration agreement, you should still keep in mind that you do need to update it, right? It's not enough to simply have your employees sign an agreement when they're hired and then, you know, they're good for all perpetuity. It's really important to make sure that your agreement is enforceable under the constantly changing rubric of what constitutes an enforceable arbitration agreement in California in particular. So what we do recommend is that you have a process in place to both kind of keep track of what arbitration agreements you have out there, and to make sure that they're, you know, current and updated. Similar to, you know, most employers are used to doing this with regard to handbooks. You know, we recommend adopting a similar process with regard to arbitration agreements, especially in the past 5 or so years with the current changes to PAGA and class and collective action waivers, making this more important. So the first thing you'll want to do is determine kind of who is going to be covered by your arbitration agreement. You know, this can be region specific, this can be employee category specific. You know, it's also very important to keep in mind that your union, assuming you have unionized workforce, will have be very important to keep. They will need to sign off on any arbitration agreement as well. Kind of the complexities of dealing with the unions is far beyond the scope of this short presentation, but that's another factor to keep in mind as well. The other thing that we briefly touched on but didn't cover is whether the agreement will be mandatory or voluntary. We do generally recommend that it be a mandatory condition of employment, but that is a decision that should be made. And you know, if it's a voluntary agreement, then that can help both with enforcement and with certain kind of internal negotiations, whether it's with the union or whether it's just with your workforce itself. Generally, voluntary arbitration agreements are looked upon more favorably than mandatory ones. Once you've decided on who should be covered by the arbitration provision, you need to figure out how you're going to communicate it to the employees and any kind of other parties that might be kind of have an interest in this, in particular with your unions. So we recommend that you do have a regular, internal FAQ, a webinar, basically clear policies that show how the arbitration agreement is going to be implemented and how it's going to kind of mesh with your existing policies, any existing agreements that you already have. One thing that we've noticed more recently is a lot of third-party a lot of healthcare companies are working with third-party staffing agencies to kind of source various categories of workforce, whether that's nurses is a very common one. But a lot of those third-party agreements with the staffing agencies, either the staffing agency themselves has an arbitration agreement, the contract between the healthcare company and the staffing agency can provide for or require the staffing agency to enact an arbitration agreement. Technically, the position that we generally take is those staffed workers are employed by the staffing agency, although again, far beyond the scope of this brief call. But to the extent you have any contingent staffing, temporary workforce, it's also very important to make sure that you have an arbitration agreement there, in particular because neither the staffing agency nor the healthcare company has complete control over all policies and procedures, and so you end up with far more complicated issues than if it's an employee solely of one entity. And so an arbitration agreement is often very helpful there. There are certain arguments that you can make about having the arbitration agreement as a third-party beneficiary, which can allow basically, in many contexts, the healthcare company to kind of take advantage of and be, covered under the staffing agency arbitration agreement, even though they aren't technically a party to that agreement, they can enforce it as a third-party beneficiary. However, if you kind of deal with those issues in advance, and whether you have a specific agreement with the people who will be working in your workforce that are covered by the agreement, or whether you have the staffing agency or the healthcare company have their own agreements separately. Those are conversations that are worthwhile to have in advance of any litigation that may occur. Can we go to the next slide, please? Apologies, I have getting over a sore throat. And the final thing I want to cover here is an issue that we've seen a lot more frequently. As Daniel mentioned, a lot of employees and plaintiffs have been challenging arbitration agreements under a variety of arguments. The kind of most common argument maybe 10 or 15 years ago was that the agreement itself was unconscionable because it didn't provide for all of the protections that court provides for. It doesn't have all of the procedures, which is where the Armendariz kind of list of requirements came from. And, those are fairly easy to address. You just make sure you have a good arbitration agreement that addresses all of the issues. The more recent type of arguments we've been seeing from plaintiffs' counsel have been challenges to the enforceability of the agreement on the grounds that the employee did not sign it. Now, this typically is a very, it's presumed, right? The employer can introduce the agreement with their petition to compel arbitration and say, here's the agreement, they signed this, and let's move on. However, a lot of plaintiffs' counsel are introducing in their opposition a declaration from the employee which simply states, I don't remember signing this agreement. And that's enough to shift the burden back onto the employer to introduce evidence in the form of a declaration, an exhibit, to show that this was signed, this arbitration agreement was signed by the employee, and that their signature was effective to bind them to this agreement. There's a couple of ways this argument can play out. However, typically when this happens, it's in the context of there's been a lawsuit, there has been a petition to compel arbitration, the plaintiff opposes, and the employer has a couple of weeks to prepare a reply, which is supposed to introduce all of this new evidence. And if you haven't prepared this in advance, it can be a mad scramble to try to make sure that you can present this evidence in a compelling manner to the court, simply to prove that the employee actually signed the agreements. Now, in general, what we've done and what has been successful in the past has been having some declarant from the company who can say, I'm familiar with the business practices. This is exactly how these arbitration agreements were rolled out. This is what the employee sees, right? Here are screenshots from whatever system is used to get the signature from the employees. Sometimes it's what we call a wet signature, a signature by hand on a piece of paper. Much more common these days is either using Salesforce or one of the many HR tools that are available to collect signatures. And even then, it's important to show that this particular individual had a unique username and password, that they submitted information that was uniquely known to them. Often in the case of onboarding, that's bank account information or personnel information. Therefore, we know that it was this employee who did this signature. Because a lot of plaintiffs' counsel are arguing, and courts are accepting that simply having a unique signature or unique username and password is not enough to prove that this particular employee signed this particular arbitration agreement, right? And so having that information in advance, identifying that declarant, even preparing a draft declaration and knowing where to go to get the documents about any specific employee's arbitration agreement can be very helpful to just collect that. So you don't have to do it in the course of a week or two when you're trying to prepare a reply brief to enforce your arbitration agreement. All right, so if we can go to the next slide, I believe that's it. Unless you have anything else you'd like to add, Daniel?
No, nothing to add. We do offer CLE attendance for this presentation. In order to get CLE credit, please scan the QR code. And the important part is that you write down the attendance verification code, which is SS1000. That's SS1000. I don't see any questions in the Q&A, so with that, thank you for attending this very high-level overview of arbitration agreements. And if there are any questions, you can reach us at the very next slide. Yes, thank you, at our respective email addresses and phone numbers, which are presented here. Thank you very much.
Thank you. Have a great day.